Mr. Brandy.
Thank you very much, my lady. Lady Justice Laing asked about the regulations, I think, for the time limit.
Oh, yes, please.
It's the homelessness review, homelessness, open brackets, review procedure, etc., close brackets, regulations, 2018. And that's statutory instrument number 223. And the time limits are set out in Regulation 9.
Thank you.
Those regulations, my lady, are made under Section 203 of the Act, which is at page 70 in your authorities bundle, my lady. Section 203(1), you don't need to look at it, my lady, I'll read it to you. The Secretary of State may make provision by regulations for the procedure to be followed in connection with a review under Section 202. Nothing in the following provisions affects the generality of this power.
Okay, that's very helpful.
The 2018 regs replaced earlier 2006 regulations, I think, from my memory. There were previous regulations about time periods, but they've been amended. They were changed largely because of the introduction of the provisions in the Part 7 that deal with trying to prevent homelessness by the Homelessness Prevention Act.
Thank you very much.
My lady, in relation to ground C, in effect, it's the local authority's submission that it's clear from a review of the documents that all of the documentation that was necessary to be satisfied of the requirements in Article 3 were produced before the offer was made. And it's clear that they were produced for the local authority and therefore on the date on which the local authority made the offer it could be satisfied of the Article 3 requirements. Subject, and I accept this, to you not having been provided with a copy of a report that says it's the report of the premises made before the 8th of January and it's wrongly dated in the letter of the 21st of January. In my submission, to suggest that there isn't such a report would mean that the drafter of the letter must simply be making that up.
Well, it may be that the letter's written on a standard template and the person who wrote the letter didn't check it.
Well, my lady, they had to put in a date, so it's unlikely if it was written on a standard template that the date was that obviously would have taken some conscious thought.
Not very much conscious thought, as they got the date wrong.
Oh, on the face of it, no. I accept that. What we also know, though, is that by the 25th of January at the latest, but probably before that, an inspection of the premises which is carried out and is Schedule 3 to the tenancy agreement indicates that if there was that report before the person making the offer, there was certainly the basis upon which they could be satisfied of the requirement in paragraph 1A of Article 3. So in effect, the schedule that we have to the tenancy agreement clearly sets out premises that are in a reasonable condition, or in any event, premises in relation to which the local authority could be satisfied that they were in reasonable condition.
If the matters in Schedule 3 were available to the local housing authority at the date when the offer was made.
Absolutely.
Yeah.
In relation to my Lady Justice Lang's point about, well, Mr. Norton didn't know that the rent has to stay at the local housing allowance level. The matters that are that's not one of the matters that is referred to in Article 3, the level of the rent, but in any event, those are matters for which, in respect to which the local authority has to be satisfied, not Mr. Norton.
Because they have to be satisfied that it's suitable.
Yes. As soon as accommodation became unaffordable for an applicant, and there's a lot of litigation about unaffordable, or a lot of appeals about what is affordable and what you have to take into account in relation to affordability. And I know my Lady Justice Asplin at least had to consider some of them reasonably recently. Then the property ceases to be suitable as soon as it becomes unaffordable. So I hope that assists in relation to the tenancy agreement, not telling Mr. Norton that the rent would not go above the local housing allowance. Dealing next with ground A, my Lord Justice Mayles has effectively indicated that this is a very small point, and the only question is, what is the effect of section 195A? Is the effect of what section 195A include the determination of the date when somebody is homeless, or is it simply limited to the fact that if somebody makes a second application within 2 years of acceptance of a PRSO, subject to the local authority finding that they are homeless before the end of that 2-year period and not intentionally homeless, they don't again have to establish to the local authority that they have a priority need. And in my submission, the effect of subsection 195A is clearly the general proposition that if somebody makes a second homelessness application within 2 years of their acceptance of a PRSO, if when they make that application they are homeless and eligible for assistance and they didn't become homelessness intentionally, effectively the section 193 duty is revived. The direction in section 195A2 is in effect a direction to the local authority in my submission. It's saying to the local authority, the deemed date of homelessness for the purposes of this section is the date on which a section 21 notice expires, and not the date on which somebody is eventually evicted. And in my submission, that is not part of the effect of section 195A. And my learned friend says, well, that might cause some prejudice to the applicant, and therefore they should be warned of that. Well, in my submission, there are other aspects of this Part 7 of the Housing Act which potentially cause prejudice, and which have been held effectively not to be required. There are notice provisions in Part 7 of the Act which still might cause prejudice and have been found to be lawful. So when you make someone an offer, you have to tell them about their right to request a review, but you don't have to tell them about their right to request a review if they also accept the offer. Well, you can see that might cause prejudice to them.
If we're to construe the section by reference also to other parts of the Act,
yes,
and you've referred us to an example,
yes,
I think you should at least give us
right,
the numbers of the sections in question,
certainly,
so that we can
yes,
see whether they are relevant to this
yes,
construction exercise.
Yes, absolutely. I don't say that. What I would say is that in these circumstances, the fact that somebody caused somebody prejudice isn't necessarily a basis for construing the words of the legislation in a wider form than the meaning of the words. My learned friend says on the respondent's part, our interpretation requires the insertion of some words into section 197. 193 7F, I think it is.
But would not somebody who is only told about subsection 1 and not told about subsection 2 be entitled to think if at the end of the 2-year period he has been given a notice which
yes,
has expired but he has not yet been evicted and is still living in the property, and he looks at section 195A1 and says that one of the requirements for this is that the local authority has to be satisfied that the applicant is homeless. And he thinks to himself, well,
Right.
I'm not homeless. I might be quite soon when the bailiffs come round, but I'm not now, so there's nothing I can do.
That might very well happen, and I accept that that is a prejudice to them.
In that case, he's not been told the effect of section 195A, which is that he's not. That he is homeless.
Yes.
At an earlier stage.
Yes. So, in order to understand this, it's my submission that we need to consider in more detail section 21 of the Housing Act and how that operates. But I accept that there is some prejudice if people are not told.
But it's not really a question of prejudice. It's just a question of, has he been told the effect of the act? And the effect of the act in that situation is that he is homeless.
Yes.
But he's been given information which makes him think that he's not homeless.
What section 195A says is, if you make another application within 2 years, the local authority will have to effectively determine whether or not you were homeless.
Yes.
Yeah.
So it isn't for him to determine whether, or her to determine whether or not they are homeless. It is for the local authority to determine whether they are homeless. So the sensible position is, on receipt of your section 21 notice, to make your homelessness application.
Yeah, but what section 193, open brackets, 7 capital AB, close brackets, little c, requires local housing authority to do is to tell the applicant the effect under section 195 capital A of a further application.
Yes.
So you turn to section 195A and you see 195A subsection 1, but then you see a particular rule about when you're treated as being homeless,
Yes.
which only, as I understand it from the submissions we've heard, this particular rule only applies if it's a section 195A case.
That's right.
So that is part of the effect, isn't it?
Well, in my submission, it's not part of the effect. The effect of section 195A is that if you make a further application within 2 years, so it's your application that must be made within 2 years, not the determination of your homelessness in the first case, in the first instance. So if you make an application within 2 years, if the local authority is satisfied that you are homeless and eligible for assistance, and is satisfied that the applicant, and is not satisfied, I apologise, that the applicant became homeless intentionally, then there is a new section 193 duty to you without determining whether or not you have priority need. It is for the local authority to determine whether or not you are homeless and whether or not you are homeless intentionally. So in effect, you have to make your application within 2 years. The determination of your date of homelessness is for the local authority. So that's not information that the applicant necessarily needs.
Well, he does, doesn't he? Because the 2-year period might expire. And
If he doesn't make his application. So
Yeah.
make your application within 2 years.
Yes, but if you don't know that the Section 21 notice having expired, you're treated as homeless because you're still in the property for
Yes.
some reason, and the 2 years therefore expires, then you've lost the benefit of
You have.
sub 1.
Yes. And you lose the benefit of paragraph 1 if your tenancy, let's take this case as an example, it's a 2-year fixed term tenancy. If no section 21 notice is served expiring on the last day of the tenancy, Mr. Norton will lose his protection under section 195A because the tenancy will continue for more than 2 years. So he'll lose his protection under section 195A in those circumstances. But if you are told, if you make another application within 2 years, and it is for the local authority to determine whether or not you are homeless, it seems to me that tells you what you need to know. And when you receive your section 21 notice, you should make your application for homelessness. So in my submission, it would take a very, how can I put it, unconcerned applicant who has been offered a PRSO and told the information in section 195A1 on receipt of their section 21 notice not to make their application for homelessness because they know that they have to make it within 2 years.
But they also know, if they read section 195A1 or what they've been told about it, that it's an application which is bound to fail if they're not homeless. And there will be circumstances where they are not homeless because they've only received a notice, but they still have a home. Whereas the effect of subsection 2 is that it will fail. It will succeed because they are treated as homeless.
My lord, yes.
And that's the, well, perhaps we're going round and round the same.
We are, and I agree. I accept that, but it's my submission that is that section 1952 is directed to the decision that the local authority has to make as to somebody's homelessness on a particular date, and not directed to the information that was useful for the person to have because they know that they have to make their application within 2 years.
All right, well, I think you're probably right to bring me up on expressing it loosely as the effect of section 195A, because you're right to point out it is the effect under that section of the application.
Yes.
Yeah, okay.
Thank you very much. So that's the response in relation to ground A. Insofar as ground B is concerned, the date on which the local authority has to be satisfied that the person who has made the offer can end their obligations is the date on which they approve a private rented sector offer. So that's section 1937F. That's at page 36. So that's page 36, my ladies, my lord, in the authorities bundle. Now, I don't think my learned friend took you through subsection 1937F before going straight on to subsection 8. So if I could do that. 7F, the local housing authority shall not, and it's a 7F AB, approve a private rented sector offer unless they are satisfied that the accommodation is suitable for the applicant and that subsection 8 does not apply to the applicant. So it's again an issue for the local authority to be satisfied. It's not to be determined on whether or not he could, but it's to be determined on whether the local authority is satisfied of the factor in section 8, and the date on which they are to be satisfied is the date on which they approve a private rented sector offer. In this case, we know that the private rented sector offer was approved on the 8th of January, because that's when the offer letter is sent out, having received on the same day the nomination notice. So subsection 8 says, this subsection applies to an applicant if the applicant is under contractual or other obligations in respect of the applicant's existing accommodation and the applicant is not able to bring those obligations to an end before being required to take up the offer. On the 8th of January, the local authority, because it is a party to, or it is referred to in the licences, knows that Mr. Norton can determine his obligations under the licence on 7 days' notice. If you turn to page 20 in the supplemental bundle, that is an email from Mr. Norton to those instructing my learned friend HMB solicitors. I have just spoken to Mohammed and agreed to meet tomorrow to sign the tenancy. He has agreed to try and source a double bed and a single bed and a wardrobe. I was mistaken in thinking the new property had full white goods, but apparently we do not have a fridge freezer. We will need assistance with this. I have not heard back from Children's Services. Can we get a response on my request for assistance? We have agreed the tenancy start date is the 21st of January 2021. I have been asked to start packing. So it was Mr. Norton who agreed that the tenancy on the 20th of January, apparently, that the tenancy should start on the 25th of January. It was him who effectively made it impossible for him to give 7 days' notice.
But you're then turning the burden onto the prospective tenant, aren't
With
you?
respect, I'm not, my lady. What I'm saying is the local authority, when it approved the offer, had to be satisfied that Mr. Norton could end his obligations under his licence agreement before being required to take up the tenancy agreement. On the 8th of January, there's no doubt that he could have determined his obligations under the licence agreement before the 25th of January 2021. He doesn't have to just give 7 days' notice. He can give more than 7 days' notice, but it's not less than 7 days' notice.
But he can't give his notice, can he, until he knows the start date under his new tenancy?
But he agreed the start date. So the local authority is in a position where it can say, we are satisfied that you can end your contractual obligations in relation to your tenancy. You should know your contractual obligations under your licence agreement. It's not our fault that you agreed that your tenancy should start on a date shorter than the notice requirement that you give.
Is this a new point?
It doesn't appear in our skirting argument, and it arises as a result of my learned friend taking you to this. It arises partly in relation to my Lady Justice Lang's questions about the contractual obligations under the licence. So the licence says it requires 7 days' notice, but it doesn't have to be 7 days' notice. It could be more than 7 days.
But wouldn't we need to know other facts in order to evaluate what you're saying? For example, the circumstances in which the start date came to be agreed. It's one thing, for example, if he said, I'd like it to be the 25th of January, is that all right?
Yep.
It's quite another thing if somebody said to him,
It must
be
be
25th January, take it or leave it.
My lord, yes, I accept that. But the question is, was the local authority in a position to be satisfied that Mr. Norton could determine his contractual obligations before he was required to take up the tenancy agreement?
Doesn't subsection 8b require the local housing authority to know, when it makes the PRSO, the date on which the tenant will be required to take up the PRSO?
My lady, no.
Isn't that what the language means?
My lady, no, it doesn't, because all it requires is that the applicant is able to bring his obligations.
No, because it says before being required to take up the offer. Surely it's a question of fact when the tenant is required to take up the offer.
Well, my lady, in this case, it appears that Mr. Norton was in a position to be able to negotiate with Haringey Community Benefit Society to be able to decide a start date. But on the 8th of January, he was certainly in a position to be able to give notice in accordance with his licence agreement that would have determined his licence agreement before the 25th of January 2021.
But isn't that unrealistic? Because on the 8th of January he's being offered this and he's then being told you're going to have to go and have a look and all those other things that are going to take place. So to say, it's very artificial to say on the 8th of January, inevitably there are more than 7 days between then and the 25th.
My lady, I accept that, but in my submission it's not as simple as it's been presented by my learned friend. The offer, the date on which the local authority has to be satisfied is the date on which it approves its PRSO offer. That was not the 21st of January when Mr. Norton signed his tenancy agreement.
No, but you have to ask yourself, of what does the local housing authority have to be satisfied at that date?
Yes.
And it has to know when the tenant will be required to take up the offer, because otherwise it can't be satisfied of the matter referred to in 8b.
Well, with respect, my lady, I don't accept that, because it seems to me that if the position is that the tenant can say to Hammersmith Community Benefit Society, I still have ongoing obligations under my licence which I can't bring to an end for 7 days, do you agree that I give my tenancy agreement starts 7 days after execution? Then that would satisfy subsection 8b.
Does this tie in with the 2012 regulations? Because one of the things the authority has to be satisfied of is suitability, and under those regulations, one of the suitability requirements, J, is that they have the written tenancy agreement, which one might think would include the start date, so they're supposed to have that before they make the offer, which rather, if that's a correct analysis, might undermine some of the submissions you've been making in relation to those regulations.
Well, my lord, in my submission, the start date is not vital for the local authority to know in relation to Article J, because the tenancy agreement is going to be a fixed term from the date on which it's granted. That's what we're told by the PRSO offer. So the local authority doesn't need to know the start date in order to approve the tenancy agreement. And you'll see that in the documents that flow backwards and forwards between the local authority and Hammersmith Community Benefit Society, there isn't in fact an indication of when the start date would be. And the letter, the offer letter, leaves that open. Mr. Norton is given an opportunity to, if you turn to page 16, my lady, my lord.
Page 16.
Page 16, I apologise, of the supplemental bundle.
Okay.
You will be, there's a heading, viewing the property. You'll be given an opportunity to view the property before you sign the tenancy agreement. An officer from our acquisitions team will be in contact with you shortly to arrange a viewing appointment. Even if you think you might not like the property, it's very important that you attend the property viewing. You may find when you see it there are valid reasons why it might not be suitable. We would strongly suggest that you seek legal advice if you think you want to refuse the offer. So it's clear that at that stage the local authority cannot say when the tenancy agreement is going to start.
No.
But in my submission, the local authority can be satisfied that, given that Mr. Norton can give 7 days' notice to determine his licence agreement, he is in a position to be able to determine those obligations before his tenancy commences. If that submission isn't accepted, I would then make the submission that's set out in our skeleton argument, which is in effect that insofar as the licence fee was concerned under the licence agreement, that was payable by Mr. Norton to the London Borough of Haringey. Who then pay the accommodation charge to the supplier. So that's clause 4.1 of the licence agreement, which is on page 2 of the supplemental bundle. As indeed happened in this case, on a number of, certainly in relation to the taking up of the flat 3 offer, the local authority can presumably be satisfied that it knew that it would not require Mr. Norton to pay it the accommodation charges. Indeed, it goes further than that. It appears that where the local authority end a nomination with one of the interim accommodation suppliers, that licence is then regarded as ceasing on the day on which the termination takes effect. So if I could ask you to turn to page 95 in the supplemental bundle. This is a notice of cancellation from Homes for Haringey. saying, I write to confirm that Mr. Thomas Norton was cancelled from flat 3, 403 London Bridge Road. The relevant purchase order is number. The last night that will be paid for is the 1st of November 2020. And so where the local authority terminates or cancels the referral of Mr. Norton for a licence to one of the providers with whom the London Borough of Haringey has an arrangement, in effect his obligation to pay any licence fee is determined on the date on which the cancellation takes effect.
So this cancellation was long before the...
I'm just using this one as an example, my lady, to show you the operation of the system. So if you turn over the page to page 95, that's an email dated the 1st of November.
Withdrawn, okay.
Yeah, and then if you turn over the page again to page 97, you'll see there's another notice of cancellation in relation to the same premises on the 17th of November.
But this is I'm so sorry to interrupt, Mr. Grime. This is dealing with the arrangements between the local housing authority and the supplier.
It is.
It has no impact at all on the obligations which are owed by the appellant to the supplier under the terms of the licence.
Well, what the concern in this respect, as I understand it, is that Mr. Norton couldn't end his liability for licence fees.
Yeah.
But we know that the licence fees were payable by Mr. Norton to the London Borough of Haringey.
I understand all of that, but what the statute refers to is not whether or not the local authority has an arrangement under which it won't pay the supplier and so on and so forth. The statute refers specifically to the obligations owed by the applicant in respect of his or her existing accommodation. So that must mean the obligations imposed by the existing tenancy or licence agreement. My point is simply that what factually happened between the supplier and the local housing authority does not in any way affect the applicant's legal position, which is what the statute is looking at.
If I could answer that in this way, my lady, what the local authority has to be satisfied of is that Mr. Norton can determine his contractual obligations under his licence.
Yes.
The one that, as I understand it, is being ventilated is his obligation to pay licence fees.
Yeah.
His obligation to pay the fees is to the local authority. The local authority is not enforcing that obligation, and therefore it can be satisfied that he is under no obligation after the date on which one of these licence agreements, one of the referrals that's given rise to one of these licence agreements is terminated.
Sorry.
The point I'm making is simply that the notice of cancellation does not have any relevance to this point because it is dealing with a different legal arrangement.
So my lady.
So what evidence do you have that the local housing authority was not going to enforce the obligations under? The supplier was not going to enforce the obligations under the licence.
Well, the supplier was paid by the London Borough of Haringey.
Yeah.
And it's Mr. Norton's obligations that one is concerned about. He was paying the London Borough of Haringey. The London Borough of Haringey knew that it wasn't going to recover any money from him.
They were not parties to the licence.
They were not parties to the licence, no. But you'll see that the arrangement that's set out in clause 4.1 of the licence agreement at page 2 is, it's clear that that is being given effect because the notices of cancellation that I've taken you to indicate that the last night that will be paid for is the date on which the cancellation notice takes effect. So the local authority is saying to the supplier,
as between us, the arrangement is cancelled But the local housing authority is not giving 7 days' notice.
It hasn't.
No.
No, and the local authority, but by providing the notice of cancellation, the local authority has brought to an end Mr. Norton's obligations to pay licence fees to it, and therefore it can be satisfied that he has no obligation that's continuing.
But by what legal mechanism has the local housing authority brought to an end the obligations owed by the appellant under the licence agreement?
Insofar as they are obligations other than to pay rent, it hasn't.
Right. And insofar as they consist of obligations to pay rent?
Well, the local authority is paying the licence fee, sorry, not rent, the licence fee to the supplier, and Mr. Norton is paying the local authority. And we know that the local authority doesn't enforce that after a notice of cancellation has ended the referral of Mr. Norton to the supplier.
I see.
So it's, in effect, it can be satisfied that there aren't any obligations. To pay licence fee on Mr. Norton after it has terminated, served notice of cancellation in relation to a referral that's given rise to a licence agreement.
Look, clause 5, for example, of the licence, which is at page 4 of the supplemental bundle, which is
Yes.
determination, and not surprisingly, given the remainder of the clauses in the licence, which
Yes.
are between the supplier and the occupier, and clause 4 contains the occupier's obligations.
Yes.
Clause 5 is about determination, and it says the rights granted in the licence are to be determined. 5.1.1, immediately on notice given by the supplier at any time following breach of the undertakings in clause 4, which is nothing else is paying, and 5.1.2 on not less than 28 days notice given by the supplier to the occupier,
Yes.
etc. So that is a relationship between the occupier, Mr. Norton, and the supplier of the accommodation, and that is how that relationship, including the obligations in clause 4, are determined.
My lady, I accept that, and
Yes.
the protection that is given to Mr. Norton is that if the London Borough of Haringey serves notice of cancellation and he doesn't move out, the supplier, the licensor, has to give him 28 days notice. If he wants to leave and the local authority haven't done a notice of cancellation, he has to give 7 days notice.
Clause 4.28, page 4.
Yes. But if the local authority served cancellation notice, his obligation to pay the local authority any more licence fees.
But where in the licence agreement does it say that if the local authority serve a cancellation notice on the supplier, the licensee's obligation cease?
It doesn't say that in the agreement, but it's
Okay,
what.
well, just let me get the note
Yeah.
of that, please. So, nowhere in licence does it provide that licensee's obligations cease if LHA serves cancellation notice. All right, thank you.
The point that the way in which I'm trying to put this submission, my lady, is this: because the local authority has served the cancellation notice, it can be satisfied that Mr. Norton will not have any further obligations under the licence agreement. It doesn't matter whether or not he can bring them to an end or not, because there are no more.
Well, I think you'll make a slightly different point, which is that the local authority, the local housing authority, might be satisfied that the obligations would not be enforced, but that's a different point. So if the statute said something about the obligations not being enforced,
Yes.
that would be one thing. That's not what the statute says.
No, it doesn't. It says it is under contractual or other obligations in respect of the applicant's existing accommodation. And what we say is that when there's a notice of cancellation.
Well, I think I understand your
Yeah.
submission.
Well, thank you very much. I won't make it again then. And my lady, we can see that that is what's happened in practice. It isn't suggested that Mr. Norton has at any stage had to pay licence fees in relation to the flat he was in at the time that the offer was made at 27 Before Road, I think it was, and in relation to flat 3, Elisabeth Bakewell House. And so the fact that these cancellation notices say that no more money will be payable on the date of cancellation is given effect to, the evidence that that is what happens is supported by what happened in this case. And so when the local authority approved its PRSO offer, it could be satisfied. Because the issue is not whether or not Mr. Norton was subject to any other contractual obligations. It's whether or not the local authority, on the date it approved the offer, could be satisfied that he was in a position to be able to get himself out of them, or that they could be brought to an end otherwise. Because if they were brought to an end otherwise, he wasn't under a contractual or other obligation.
But it doesn't say brought to an end otherwise. It says
No,
the
it doesn't.
applicant is not able to bring those obligations to an end before being required to take up the offer.
I hear that, Malay. What I'm saying is, if they are brought to an end, he is not under contractual or other obligations.
But then you have to look at the contract, have we said, and we've had a look at that.
You have.
Thank you.
And then in relation to ground D, in my submission,
Sorry, before you get to that,
Yeah.
Can we just explore the consequences of these various grounds that we've been investigating?
my lord, yes.
Ground D, which you're coming to, goes to the definition of a PRSO. So if it's not an offer made by a private landlord, or if it's not made with the approval in pursuance of arrangements, etc., then it simply isn't a PRSO, and therefore the provisions about what happens when there is a PRSO don't apply, because this isn't one.
Yes.
When we then turn to section 195, so and subsection 7AA of
Yes.
that, the effect of failing to explain the effect of a further application to a local housing authority under section 195A is that it remains a PRSO because it falls within the definition, but it doesn't discharge the duty.
Absolutely.
Okay, right so far. Then subsection 8, which is contractual obligations, the ground you've just been on.
Yes.
Now that simply says that the local authority mustn't make a final offer unless it's satisfied that subsection 8 doesn't apply.
Yes.
It doesn't go to the definition of a PRSO, and it
No.
doesn't say anything about discharging the duty. It's just that the local authority shouldn't have done it, and is
No.
therefore in breach of presumably a public law obligation, and maybe one which gives rise to private rights. I don't know. Is that the right analysis?
My lord, that is the right analysis, yes.
So what's the consequence of this case if you're wrong on subsection 8?
The consequence is that the offer is still a PRSO, and that Mr. Norton has some claim against the local authority for being in breach of clause 7F/8.
But if that's the only ground on which he succeeds, then it doesn't affect the fact that your duty has been discharged.
It doesn't, no.
No, I see. Right, thank you. So you want to go on to
Ground D.
ground D.
Excuse me a moment.
Perhaps before you do so, sorry.
Yes, mine.
But surely, if there's a breach of 7FAB, i.e. subsection 8, the offer of the PRSO was made ultra vires. So it's just simply void.
That was what I was just going to ask Mr. Grundy to address.
My lady, yes.
In the sense that 7F says local housing authority shall not make a final offer. And if one does, then surely it's no offer at all. And I just want to know what you said about that.
My lady, yes. So in relation to that, given the way in which the other subsections of subsection 193 are phrased, in my submission, by saying this is not a PRSO in these circumstances, the way in which section 7F is phrased is different. And in my submission, that gives rise to the fact that this still satisfies all the requirements of a PRSO.
But if 7F and subsection 8 were breached, it was void. So it might in theory have satisfied the definition in other respects, but the offer was a nullity. Because it should not have been made.
Well, in my submission, my lady, it would still satisfy the requirements of a PRSO.
Yes, I just accepted that.
It was made.
Yes.
So in those circumstances, it is a PRSO until it is set aside.
Right. So if the consequence, so in other words, if we don't accept your argument about 7F and subsection 8, the consequence is that the PRSO would have to be quashed.
The consequence is there would be a power in the court to quash it. Yes.
Yeah.
But that then would give rise to whether or not, in these circumstances, it would be an appropriate case in which to quash, given that the prejudice to Mr. Norton of this being a PRSO in circumstances where no contractual or other obligations in respect of his previous accommodation have been enforced against him. There's no evidence that there were, and I don't believe it is said that they were, if I can put it like that. It's not said that he suffered any prejudice as a result of that, other than this not then being a PRSO. So you have the power to not to grant relief in circumstances, in my submission, where the applicant doesn't suffer any prejudice as a result of the breach.
And where does that come from?
I thought that's the Connor case. O'Connor and Kensington and Chelsea Royal London Borough Council, which is tab 3 of your authorities bundle.
I may have set an unnecessary hair running here.
So paragraph 42, my lord, my ladies, Lord Justice Waller, discretion.
Can we just have a look at the underlying facts? Because I'd like to know, does the paragraph tell us about the, well, okay, which paragraph do you want us to look at?
Just paragraphs 42 and 43, my lady.
That's all just about whether it's pointless.
Yes.
But I don't think that really helps us here, does it?
It's I accept, my lady, that it's stretching. It's not on all fours with these circumstances. But in my submission, as a general proposition, that the relief in judicial review.
But this isn't an application for judicial review. It's a statutory appeal on the point.
It is, but it's on. I don't think it's in dispute that it's on judicial review principles.
Well, depends what you mean by that. I mean, the issue,
Well, I think
it's an appeal on the point of law, which means that you have to find some public law error which vitiates either the original decision or the review decision.
My lady, yes.
But I'm not sure it follows from that the principles that apply on judicial review in relation to relief necessarily also apply. I mean, there may be some authority that tells us that, but I'd like to know what the authority is.
Because certainly where I am at the moment is that if 8 is not satisfied, then 7F says that the housing authority shall not make a final offer. And if it has made a final offer, then that offer must be void, and we can't exercise a discretion of the kind that one finds in O'Connor in order to make something which was void not void, or valid even.
So my submission is that it is valid until it's quashed.
Oh dear. That's another rabbit hole.
Circles.
Yeah.
Circles. Thank you.
All right.
Sorry, where are we? I think we were going to ground D.
We've got to ground D. Mm-hmm. I need to remind myself how it's put.
Me too.
Sorry.
Made with the approval.
Yeah, ground D is made with the approval. In my submission, this is very simple. There's enough in. We know about, even before we had the evidence of Mr. Levitt, the offer letter sets out the relationship between London Borough Haringey and Haringey Community Benefit Society, to the extent that it must follow that the offer has been approved by Haringey. And indeed, my learned friend took you to the nomination, the application for nomination, and the nomination. The nomination is made by the London Borough of Haringey, having received the request for nomination from Hammersmith Community Benefit Society, and in my submission that must amount to an approval of a.
Well, I think Mr. Johnson effectively conceded this ground, didn't he, when he was on his feet?
Well, I think he was saying there should, as I understood it, he was saying there should be some document that says the offer is approved.
Well, I did ask him about that, and my impression from his answers to my questions was that he effectively conceded that what one could draw a secure inference from the making of the offer in the letter of the 8th of January that the local housing authority had approved it.
My lady is.
I think he's nodding.
I know, because I don't need to make any submissions on ground D. Ground E, I adopt what my lord and my ladies said. My ladies and my lord said. Ground F, I don't think adds anything at all. So those are our submissions in response to the grounds A, B, and C, effectively.
Thank you very much indeed, Mr. Grundy. Mr. Johnson?
My ladies, my lord, the only matter on which I think I might need to make reply is the point made by my Lord Justice Bales, and in relation to the matter left open by BNLJ about the validity of a tenancy agreement that hadn't been seen, and whether or not, if there was a template that had been received, that was sufficient pursuant to an overarching umbrella agreement. This case, and the point made by my Lord Justice Males to Mr. Grundy, makes the point as to why you do have to see the actual tenancy agreement prior to approving the offer. You need to see the start date. You need to see the rent. You need to see the term. And if you look at the template, which is in the supplementary application bundle, page, I think it's 24. This is one of the exhibits to Mr. Levitt's statement. You'll see there that it's not just the rent and the tenant that needs to be filled in, but if one goes over...
Sorry, what page did you say?
Sorry, it's
24.
Page 24, if you're using the bottom.
Oh, sorry, I
left
thought you
hand.
meant the supplementary. Yeah,
The white one.
yeah, it's the
Sorry, it's the application.
Yeah.
manual.
No, that's fine. Thank you very much.
If you have that, it's not just the tenant's name and the first rent period. It's over on page 25. It's also the period. So if you go under term, a fixed term of blank months or years from and including date. Now, of course, that's an incredibly important point Mr. Grundy put. One, it needs to be more than 12 months in order for it to be a PRSO in the first place. And second, the point Mr. Grundy makes about if it was 2 years, that might have some implication. But more than that, and specific to this case, so even if one could conclude that a template agreement can be acceptable in the way that Lord Justice Bean suggested in HHJ, even if one could suggest that, in these cases, no. And the reason why I say that is found if you go to, if I take you actually to Mr. Norton's tenancy agreement, sorry to flip you around, in the supplementary bundle, page 40, if we go forward to 51, in exchange with Mr. Grundy was placing considerable reliance on matters in Schedule 3. There's also a Schedule 2. Schedule 2 contains an inventory as to what's in the property. Now that could be highly relevant to the questions of suitability. And one of the obvious examples is an older property might have an open gas fire, which might be unsuitable for a parent with a child with autism, for example. So those sorts of matters are highly relevant. So you would need to see what was in it. But then if, as I understand Mr. Grundy's submission to be, that a local authority is satisfied of the condition of the property by virtue of the matters raised in Schedule 3, because that contains the infamous report that we haven't seen. If that is crucial and as central as Mr. Grundy submits, then of course you would have to see that before, as the local authority, you could be satisfied of the matters in the 2012 order. So where that takes...
So even if a template were sufficient in some cases, it wouldn't have been here.
Exactly.
In the absence of the report.
Maybe the problem is that the local housing authority are trying to get the tenancy agreement to do too many jobs.
That might well be the case, my ladies, my lord, there wasn't anything else which I wanted to make reply, save to make one overarching point. Mr. Grundy at various points referred to the evidence. You can draw inferences from this, there is evidence here. What categorises this case, from the respondent's point of view, is that there is no evidence of the matters which Mr. Grundy puts forward. So there is no evidence, as my Lord Justice Mayles said, about how the date of the 25th of January came to be fixed as the start date. And I'm fairly sure if one was to ask Mr. Norton, he would say, well, I was told it was that date or never. I don't make that submission because I don't know. There's no evidence on that from either side.
I think an analogous point was made in the representations that preceded the review decision. I think there's some
There
toing
is.
and froing
There's
about.
64 in the,
Yeah.
it's about 75 in the supplementary bundle. There's also an awful lot of assertions about inferences that can be drawn about the report that doesn't exist, and that you can assume that it did. Well, there's no evidence about that. The easiest thing for the local authority to have done would have been to have put in a statement at some point identifying those documents. And you'll recall from my submissions in relation to the application to admit the evidence that we talked about first thing this morning, there are circumstances in Irmakov where a local authority can put in evidence to supplement its reasons. That was never done. So it's not just the question you're being asked to do what Lord Justice Bean said in HHJ was inappropriate, i.e. to draw inferences. You're also being asked to draw the inferences yourself rather than the local authority having drawn them. If in effect it's double hearsay, if you like, you're being asked to draw inferences, the local authority drew inferences from something that we haven't seen. And so that's something that, in my submission, needs to be taken into account when looking at Mr. Grundy's submissions. There is no evidence. My ladies, my lord, there's nothing else I have by way of reply, unless there's anything in particular you wanted me to address.
I'd like to just ask you about what you say about 7F and 8, in the sense that if 8 is not satisfied, and then what is the status of the offer in this case?
The short answer is, I agree with the analysis of my ladies in relation to that, and the reason for it, and the longer answer is this. If one goes, what Mr. Grundy's doing is looking at these subsections in isolation, and you can't do that. And when I started this morning, I took you through the section quite methodically. And the reason for this is because if you start with 7AC, which defines a PRSO, and you look at 7 capital A capital C section B, it is an offer made with the approval of the local authority. That then takes you to 7F, which says you cannot approve it. Now, if you can't approve it, then it's not a PRSO. Because it doesn't fall, because you don't satisfy 7 capital A, capital C, subsection B. So if you take it from the bottom upwards, if you were under contractual obligations, a local authority cannot approve the offer. If they can't approve the offer, then 7AC, ACB says it can't be a PRSO.
Thank you.
Therefore, it's ultra vires, therefore it's void, and unfortunately the court has no power to validate.
Yes, I don't want to go over the submissions again, but I'd just like to understand, and this is also a question I meant to ask Mr. Grundy, which of these various grounds has a wider significance, if any of them do, and which are really specific to the facts of this case. So for example, I can see that the question about section 195A, or whatever it is, might have a wider significance, whereas the question whether they had a report in front of them or not is purely to do with the facts of this case. Do you have any submissions about which are of wider significance?
My Lord's quite right to identify the ground in relation to 195A as being of wider significance. And that, of course, is ground A. If you want to follow along, it's on page 12 of the core bundle in the ground.
Yes.
So, ground A is of wider public importance. Ground B, in the way in which is the question about the contractual or other obligations, in the way in which it's been advanced by the respondent, that you don't have to, it's not a question of your contractual obligations, it's a question as to what the practical effect of it is. If that is the way in which it's being put, then it does have wider implications beyond this case, because if that's right, then it gives a local authority a broader scope than the statute, we would say, permits them to have. So we would say B is of wider importance. C is this question as to whether or not the suitability order 2012 was satisfied. Now, on its face, my Lord is right. Whether or not a report existed is specific to this case. But, again, by virtue of the way in which the respondent puts their case and the way His Honour Judge Hellman dealt with the issue, it is broader. Because what was being said, and to a certain extent is repeated today, is that you can have an overarching agreement and you can draw inferences from that overarching agreement in order to comply with Article 3. So simply because London Borough of Haringey knows the Community and Benefit Society and has a relationship with them, simply because of that they are held to a lesser standard, is, as I understand it, the way in which Mr. Grundy puts his case. If that's right, then that is something that is of wider public importance. So the answer to my Lord's question in that regard is that ground C is both. Ground C is both specific on the facts of this case, does a report exist or didn't it, and it's broader if one's dealing with the respondent's submissions. Grounds D, E and F we haven't really dealt with, and are questionably relevant even to this appeal, let alone to matters more generally.
Thank you very much.
Thank you very much indeed. Thank you very much indeed to both of you for your helpful submissions today.
Oh, I wonder whether we should, in fairness, we should ask Mr. Grundy whether he wants to comment on Lord Justice Mails's question.
Absolutely, I'm sorry about that. Mr. Grundy?
It's my submission that only ground A has any wider significance. Our case isn't being put on the basis that there was some relation, that you can fudge it because there was a relationship between HSBC and the London Borough of Haringey in relation to ground C. And in relation to ground B, it seems to me that's a matter of fact in this case. So it's only ground A that has any real wider significance. What does the local authority, what of the requirements in section 195A is the local authority required to notify the tenant?
I do apologise, Mr. Grundy,
No.
for having shut you out.
I assumed you'd make your decisions anyway, so...
Nevertheless, back to the thanks. Thank you both of you for your very helpful submissions today. You'll be very well aware of how we proceed from here on. We reserve our judgments and they will be handed down in the usual way, which more often than not now is electronically, and you won't be asked, obviously, to appear. Of course, we would like you to agree all other issues on paper if you can, and if you can't, to produce very short submissions so that we can deal with those consequential issues on paper. I also ought to remind you about the embargo that there will be on the draft judgment and how very serious that is, and also any breach of it is taken extremely seriously. So I just remind you of that. I'm sure you have that at the forefront of your minds. Thank you very much indeed.
All right.